I guess I am thinking in terms of the concept of religious liberty in our Constitution and the 14th Amendment. That was a judgment by Americans that using race as a criteria is not valid regardless of
But you seem to say if we make a judgment that using gender identity is a valid criterion, that's somehow morally invalid. If we have the power to make the judgment about race, why don't we have an equally valid power to make the decision about gender identity?
I'm saying that I think it is not a good idea to do that. I'm not saying that you don't have the power to do it, although there may be a religious...
And my time's up. I think you were saying something a little different, because it's not how we define the classifications. I'm asking you about the scope of this religious conscience immunity that people have. And it seems to me that the scope has to be what the scope has to be. That you can't be one scope of immunity in case of a pacifist employer and another scope of immunity in the case of a racist employer and another scope of immunity in the case of someone who is somehow discomforted by transgender people. Shouldn't the scope be uniform across the board?
I think that the issue is not as simple as being discomforted by a transgendered employee as much as it is a deeply held religious belief. I think that under the Constitution, the race issue is a matter that has been determined.
My final point, and I don't want to hog the time, but don't you have an Establishment Clause problem with that? Because it seems to me that it says that acceptable religions, as we define them, will have this zone of immunity so that deeply held religious beliefs will exempt people from employment discrimination laws. But other kinds of religions, be they white supremacist-based, pacifist-based, don't. Doesn't that put us in the position of defining what's an acceptable religion for this exemption and which isn't?
Not when the white supremacist group cannot exercise that belief because of the 14th Amendment.
Sure they can. They can publish books that say that white people are supreme. They can do that. The 14th Amendment doesn't preclude that.
Certainly they can publish a book.
They can hold worship services that say that, can't they?
I'm sure they can.
Well, okay. Well, we may come back and explore this in the second round. Mr. Klein.
Thank you, Mr. Chairman. Thank all the witnesses for your testimony. Very enlightening as always. I want to particularly thank the lawyers that are here because it gives Mr. Andrews particular pleasure in the great battle of what is the best law school. I guess I'd have to admit that I frankly don't care. But he does, so thank you for that. Ms. Miller, and I don't know if we resolved the issue about the law school here, but you had very interesting testimony that I think is extremely important to us as we consider the possibility of statute. I believe very firmly that the language that we use matters. Indeed, when we write a law, when we pass a law, regulatory agencies often come in and write regulations that may change things somewhat, but fundamentally the language that's in statute is very, very important, and we need to be very clear about that. You mentioned in your testimony, for example, that the use of the word mannerism could be problematic. There's some discussion, we've had some discussion in this committee, in fact, recently, about some language issues that came up when we were discussing the earlier bill, the ENDA bill, using the word perceived in that legislation, which many people thought was problematic. So I'm going to look down at my notes here to make sure I get this right, but the Americans with not being a lawyer, you understand. The Americans with Disabilities, thank you. The American with Disabilities Act protects not only qualified individuals with disabilities, but also those who are, in quotes, regarded as having a disability. Some of the discussions surrounding new protections based on gender identity involve providing protection based on an employee's sexual orientation or gender identity, whether actual or, in quote, perceived. Can you tell us, in your view, is there a difference between the regarded as test under the ADA and the perceived test set forth in the earlier ENDA bill and in this bill? I think we have a standalone bill 3686. Do you know, Mr. Chairman, are we taking that up?
The committee's not made a decision on that.
I see. Go ahead.
Yes, sir. I think that there is a distinction between regarded as and perceived, and I would define it this way. Regarded as, particularly when we're talking about in the context of the ADA, would imply that there is some sort of overt act or conduct by the employer or the manager treating this individual, and they're regarding them as disabled in their treatment. Perception is something totally different. Perception can become reality, we all know that. But perceived as may be something that's a vague language that is really not actionable when it comes time to enforcement of rights, because perceived can be something that's totally internal. It's not necessarily an expression by the employer or the coworker. Regarded as, however, is language that suggests that there is some sort of a overt action taken.
So your testimony then is that there would be ambiguities which would require court interpretations if the term perceived is included.
Yes, sir, it is, and it would not just involve court interpretation. It would also involve a great deal of confusion by the managers and the human resources people in the field, and we would end up litigating over the table as to whether somebody's conduct was somebody's personal belief constituted a perception or not. We cannot legislate people being nice to each other. It would be nice to do that, but we cannot. We all know that. We cannot legislate people's internal thoughts and processes. That's part about being in America. We allow people to have freedom of thought and freedom of expression internally. Regarded as is much better language because it implies that there has been some sort of an action taken in the workplace, and then that can become the subject of any type of debate or litigation.
Okay, so as I understand this then, if we were to continue to use the word perceived, for example, litigation would surely follow, which means that you need lawyers on both sides, and these respective law schools can grow. All right, I yield back, Mr. Chair.
Full employment. Thank you, Mr. Klein. Next is Ms. Sanchez, is recognized for 5 minutes.
Okay. I'm just going to start.
Actually, Mr. Chairman, may I speak out of order for a unanimous
Sure,
consent request?
Sure. But by the way, the reason for this is that following the rule of recognizing in order of appearance.
Just for a unanimous consent
of course.
request to submit a statement in the record.
Without objection.
And to excuse myself.
Without objection. Ms. Sanchez.
Thank you. I'm going to start with a quote from Martin Luther King Jr. And he said that laws cannot change people's hearts, but they can restrain the heartless. And I think that it would do well for all of us to remember that. No, we can't legislate what people's thoughts are, but we can legislate their actions. And where we find discrimination, we can say that that is something that is unlawful. And the last time I checked, every time the Congress passes a new law, it's subject to interpretation. And yes, sometimes the courts have to decide what the statute actually means. So the idea that, oh, there's going to be all this litigation, every time we act in this body, there is that potential. But that doesn't restrain us from doing the job before us and trying to tackle the challenges that we see before us and trying to hopefully make society a better place in all different respects. I want to begin my questions with Mr. Minter. In California and in 11 other states and the District of Columbia and more than 100 local governments, they've enacted explicit employment discrimination protections for transgender individuals. Is that correct? And yet in the background materials that I reviewed to prepare for this hearing, I've learned that the Transgender Law Center in San Francisco seems to keep pretty busy in trying to protect Californians from improper terminations as well as on-the-job abuse and harassment. And one of the examples that was given was that a 13-year-old employee of